All right, Nate, are you ready to roll?
Yes.
Okay, terrific. Well, thank you, Nate, and welcome everybody to today's interactive dialogue. Today we're going to be talking about 5 key considerations in agriculture's financially uncertain times. And for those who have signed up and need continuing education credits, some information about that at the beginning. You'll see this also at the end as well. But we are offering continuing legal education credits for this program. And to get that credit, you'll need to sign and return the sign-in information that's included on the reminder email, which you were sent yesterday. Some other just information, housekeeping as we start, is that this is intended to be an interactive dialogue. I'll talk a little bit about the format in a moment. But in particular, there's a chat feature at the bottom of your screen where you can ask us questions. And I do highly encourage you to ask questions of myself, or more likely Nate, the expert. And I will monitor that. If I happen to see that you've identified something as being confidential, then I'll anonymize it. Otherwise, I might use your name or the company name or the like if we have that information. But we're happy to ask anonymous questions as well. And please feel free to ask as many questions as you like. I'll let you know if we're about to come to that question. Often that happens, and we're about to get to that particular topic. So at any event, so glad that you're with us, and fun to see so many names that are so familiar here today. So I'm very pleased to present today with Nate Seim. Nate is a partner in our Salt Lake City office, and amazingly, Nate is actually in the actual office. As you can tell from my real life Zoom background, I'm in my home office, like basically everybody today in today's world. But Nate was able to make it into our downtown Salt Lake City office. So so glad you're here with us, Nate.
Thank you. This is the first time I've been in the office in months, but I figured I couldn't trust my home office with my 3 little kids running around, and
Yeah.
a little more private. So.
Absolutely. I got to enjoy that yesterday. Your daughter's adorable.
Yeah, she is.
So for those who've not participated in an interactive dialogue, again, a little bit of information about the format. As you know, the lawyers who are watching in are familiar that many continuing legal education programs are really focused on a lot of content, tons of slides, a lawyer basically yelling into the internet for an hour to try and cover 75 slides. And this format came from a different context. It first really started with a longtime client friend in the agriculture industry and the like, Jennifer Keegan, who gave me some ideas about how to do webinars in a way that was different. And then also looking at ways that people can kind of produce content now in a more interactive format, almost like talk radio. And so what we decided to do was to try it out and to have something where we took a topic, found an expert like Nate, and really explored that topic more deliberately, with a lot deeper and more opportunity for questions for myself as somebody in the industry, and then also for clients and the like who had questions about a particular topic. So a little bit about Dorsey and myself. I'm a partner in the food, beverages, agribusiness, and cooperatives practice. I reside in Seattle, Washington, although I also work a lot in California. I'm licensed there as well. Dorsey is about a 600 lawyer firm. We have 6 practice areas, individual industry groups. One of those is the food, beverages, and agribusiness industry. I'm a member of that industry group. I'm here today with Nate Seim, who is a partner in our finance and restructuring group. And Nate, do you want to give your background and a little bit about what finance and restructuring means?
Yeah, so thanks, Mike. Happy to be here. I reside in Salt Lake. Our office is in Salt Lake. We have a beautiful view overlooking Salt Lake that's growing like crazy. I'm a partner in the finance and restructuring group, and so my practice area really is 2 sides of the same equation. I represent a lot of lenders and then a lot of borrowers, both on the front end side of deals as they're entering into lending transactions, documenting those deals, making sure that the collateral is secured properly. And then when a borrower is struggling or distressed or the loan goes into default, I am also a back-end attorney and do a lot of workouts, default, collateralization, bankruptcy, and really just help either the borrower or the lender get through that workout and default process.
Terrific. And I would say I've had the privilege of working with you. I'm not sure the clients are always so excited about talking to a workout finance and restructuring lawyer, but we've had opportunities from the front end of helping clients design their loan programs and the like, taking into account the commodity nature of products, including on international transactions and the like. Because agriculture, obviously, lending is a different kind of kettle of fish, as it were. I was trying to pick the right metaphor, but it's different because it's a commodity market often, and you're dealing with a lot of price fluctuations and a certain level of uncertainty anyway. And then also working with you on workouts, essentially trying to figure out. We've had some clients who unfortunately hit the wall. And how do you do that in a way that preserves the maximum value for the creditors and the maximum value in the co-op world for members and the owners of the business? So I've always really appreciated your guidance and advice in a really practical way. So today, this was really this particular topic was brought really because of work that I've been doing in the agriculture industry, generally speaking, and have since really the beginning of COVID time, as I call it, around mid-March of 2020, I've been working with a variety of different agriculture-related companies, everything from growers and farmers to processors, co-ops and the like, and then also retailers. I work with some grocery retailers and the like. And what I've found is that there's a lot of stress right now in the industry generally. It's stress from just normal business stress, retailers in particular, anybody who came into COVID time with already shaky financials, those companies are shutting now. And for those who sold into those retailers, then your markets are drying up. So the customers are shifting around a lot. The type of product has changed for agricultural commodities in particular, whereas you might have previously done sales in bulk packages, restaurant sales have gone to zero, and that kind of thing. So things have shifted around. Sometimes the geography of production has changed. So there's a lot of change going on, and that leads in some ways to financial distress, but then also the fear of financial distress, which is its own thing. And in other words, even if I think, okay, whew, man, I'm doing okay now, I still might be terrified about what's around the corner based on what I've seen around the last 3 corners I had to navigate. So it's been really interesting, and I've seen it in the past. Nate and I have worked together on some agricultural and cooperative issues where in a commodity world, you have something that happens like a disease hits a farm or a currency fluctuation occurs, and there's really a shift that happens in there. And so sometimes things happen that are within your control, and sometimes things happen that are outside of your control. So this is really the genesis of the program, is to try and understand what do you do when you start approaching that situation? And what we decided to do was to break this out, not just in the top 5 steps, but really top 5 steps from a perspective. So what do I mean by that? As a supplier, you might be worried that your own company is distressed. And so what do we do about ourselves? Make sure that we're in the strongest position possible. You have customers out there. And so what happens if you're concerned about those customers and the extent that they might start to falter? And then what happens about the supply chain of the products, services, and the like that you need to make your product, and risks factors associated with that? And then finally, we're going to kind of cap it off by looking at the lender perspective as well. So the idea is to kind of come away with, from various perspectives, what are the 5 things that you can do if you're seeing that type of distress in the company. Now, one of the things I've been fascinated by, I do seminars a lot on to clients and board members about what is their ethical duties and legal duties. And your first topic here is changes to fiduciary duties. And we're going to start really by talking about your own company and what happens if you're concerned your own company is at risk. So what are the fiduciary duties that you get worried about, Nate, and how does that shift if there's distress happening?
Yeah, no, and just a real quick caveat, as Mike said, we did these 5 broad topics. We're not going to go into a ton of detail on each one. If you have follow-up questions, we're happy to answer those after the fact. And you know, depending on the situation, these may not be the 5 topics that would be most pertinent to you. There may be other things that would need to be considered, but these are 5 that we see a lot. And so this first one, changes in fiduciary duty. So typically, directors and officers owe a fiduciary duty to the corporation, and those are typically duty of loyalty, meaning they're going to act in the best interest of the company, not engage in self-dealing and the like. Duty of care, they're going to be informed in the decision making that they make and make reasonable decisions. And then the duty of obedience, which is not to act unlawfully or to act in a way that conflicts with organizational documents or other documents of a company. And when a company is solvent, that fiduciary duty runs to the shareholders. When a company becomes insolvent, and it's clearly insolvent, that duty shifts from the shareholders to the creditors. And at that point, the fiduciary duty is to maximize the benefit of, maximize the assets for the benefit of creditors. And one of the issues that we get is what happens when you're in that gray area. And you know, without going into a lot of detail, at least the Delaware court has said, if you're in that gray area, you're distressed, you don't know if you're insolvent or not, you owe a duty to both sides. You have to take into account the consideration of shareholders and creditors when making decisions going forward.
So some questions about this. First of all, what is the definition of insolvency? What does that actually mean?
So insolvency, there can be multiple definitions, and in many times it depends where you are, in what state you're governing. But generally, there's 3 types of insolvency. There's the first type, which is really just a balance sheet test. Are your assets greater than your liabilities? Now, the one caveat to this is it's not a strict GAAP balance sheet test. What they call it, it's a modified balance sheet test, which means you take into account maybe not the GAAP value of assets, but what would the fair market value of those assets be currently? And then you're also looking at perhaps contingent liability and types of liability that may not necessarily show up on a traditional GAAP balance sheet. So that's test number 1. Are your assets greater than your liability? Another way to measure insolvency is, are you able to pay your creditors in the normal course of business? And if you're not, even that's a definition of, well, you're not insolvent, or you're not solvent. And then the third method that's often used is just, do you have enough capital to move forward, or are you so over leveraged that there's really no way that you can get out of this scenario?
And you mentioned that the tests vary based on the jurisdiction that applies. And generally speaking, what jurisdictions should companies look to determine what the test is that would apply?
Yeah, so I mean, look at where you're incorporated or organized. You know, we typically, when we're talking in this presentation, will follow or use Delaware law a lot, just because there's so many companies that are organized and incorporated there. And then even if you're not, a lot of states will generally follow Delaware law quite a bit. So, you know, that's something that you have to look at, your own individual state, you know, which laws are governing your governing documents and things like that. But overall, I would say in this aspect, most courts are fairly similar.
And then you said that, in most cases, your fiduciary duty runs to the shareholders, which I think most people understand, but then it can shift to the creditors. And what does that mean from a practical perspective when your duties shift to the creditor as a corporate officer or board member?
Yeah, I think at that point, you're really looking at how are we going to maximize the value of current assets that could potentially pay creditors in an insolvency type of situation. It doesn't mean that you have to go out and all of a sudden start selling every asset that you have and liquidating immediately, but it's operating with that viewpoint. Is the next decision we're going to make? Is it fairly speculative? Something that's a pipe dream that we're hoping can turn this thing around, or
the Hail Mary, as it were.
Yeah. Are we throwing a Hail Mary, from the 50-yard line, or is this something that could reasonably maximize the value of an asset or the company to pay creditors? And at least there's, I think most of the people on this call will be familiar with the business judgment rule. So there's directors and officers are generally given the benefit of their decisions, and they get the benefit of having business judgment and making those decisions. But there are limits to that. And again, if we're engaging in something that's just a total Hail Mary, then that's probably not looking at it.
And is it possible to be insolvent but still have a bunch of cash in the bank?
Yeah, no, and that happens all the time. We'll talk about this in a little while, but when a company files bankruptcy, they need a lot of cash in the bank because bankruptcy can be expensive. And so just because you have cash doesn't necessarily mean you're solvent. Again, we're looking at what are the fair value of assets versus liabilities. And if you just have a ton of liabilities out there, or even contingent liabilities that have are pretty they're still contingent, but they've got a lot of merit to them. Even if you have a lot of cash, then you can still get insolvent.
Got it. And then, briefly, although I know we could do and have actually, in fact, you and I have done presentations for a whole hour on the options that companies have. Can you kind of walk through what those are and, quick pluses and minuses to each of them, just so we can level set?
Yeah, so we just talked about it a bit ago. So bankruptcy is always an option. The pros of bankruptcy is you get the automatic stay. And so if there's a lot of litigation, if there's garnishments or things happening, it gives you a chance to kind of reset and breathe a little bit. And so you get the benefit of the automatic stay. You can reject burdensome contracts. You can maintain the organization and the going concern value for a while. And then as we're talking about fiduciary duties and liability to directors and officers, there's a lot of oversight in a bankruptcy, and so decisions aren't necessarily second guessed quite as much because you get court approval for a lot of the decisions that you're making, paying claims, like that. Downfall is, as I just mentioned, it can be expensive, and particularly in a Chapter 11, if you're reorganizing these things, can take a lot of time and can get pretty costly.
And just by way of example, for the attendees, Nate and I recently attended an in-person hearing in Boise on a bankruptcy matter. And, my quick count was that there were about 20 lawyers in the room for a farm sale. And those lawyers represented the creditors and the bankrupt person and entity and the buyers and other interested parties. So, every one of those lawyers is expensive, and it was really a visual example of what you're talking about, Nate.
Yeah, and in bankruptcy, I mean, one of the benefits again is there's a lot of statutory provisions that you comply with that help reduce liability and things like that, but making sure you go through those processes can take time.
And so what are the alternatives then, briefly?
Yeah, so receivership is one, And the benefit of receivership is it puts somebody, typically with knowledge, an experienced receiver in place, and puts a fresh set of eyes on there, that they can provide information, that they can really give you an unbiased viewpoint of what's going on. One of the downfalls is receiverships can also be a little bit expensive. I mean, typically it's a professional of some sort, whether it's an experienced accountant or a turnaround professional, and they're usually charging their hourly fee or some sort of fee that it's not super cheap. There's also no automatic stay, and so if you are the company itself, it doesn't prevent litigation and other things from happening. There's something called an ABC assignment for the benefit of creditors. Not popular in many states, but very popular in other states such as California. And that's usually a state statutory provision that acts kind of like a bankruptcy. There are certain provisions of how you go about liquidating assets, but it's less rigid and stringent. There's less rules. And so, one of the pros of that is you can get rid of assets fairly quickly and efficiently. It's less costly. One of the downfalls is that, again, you don't get the protection of the automatic stay, and you can't sell assets free and clear of liens, which you can do in a bankruptcy case. And so if the company has a lender or other secured party, you really have to work with that lender or secured party to have their liens released for you to be able to do a sale. And so there's pros and cons, and then kind of the last one that we do a lot of is either just winding down under state law or just informal wind downs.
Selling out the assets and paying off the creditors, essentially. Or transferring certain assets to the creditors in exchange for releases and things like that.
Sure. Yep.
And then, obviously, D&O insurance is really important. Generally speaking, for any officer or director, it's often the first thing that people think about when they're going on to a board is, when could I be personally liable, and how do I make sure that I've got protection from that? And so, briefly, can you talk? I think most folks are probably familiar with D&O and insurance generally speaking, but we recommend here to purchase a tail insurance. What's tail insurance?
Yeah, so tail insurance, so most insurance, or at least a lot of insurance policies, are claims-based policies, which means the policy doesn't actually get triggered until a claim is made. And if you've got somebody who's going to make a claim, they will often sit on these things even for years until the statute of limitations is going to expire. And so if they make a claim that happens after the policy term or after the policy has lapsed, then you're going to have a claim without a policy that can cover. And so a tail is something that prolongs that period for when a claim can be made, and you'll still be covered even if that claim is made after the initial policy would lapse.
So putting it in practical terms, normally if there's a lawsuit filed against me as a director or an officer, the company would be responsible to defend, indemnify, and the like, maybe through insurance. But if the company isn't around anymore, the question is, who do I turn to? And the answer is, you might only have tail insurance. Is that fair?
Yeah, that is fair. And one of the things that we always, it's like driving a car, right? You never want to know what type of car insurance you have at the time you get into an accident. That's something that you want to know beforehand. And same with D&O insurance. A lot of people get it right when the company starts. They don't think about it again for 10 years. And then all of a sudden the company becomes distressed and it becomes an issue. You want to have that in place early, and you want to make sure that the liability and coverage is enough, depending on the type of company and things that you have. I was going
to say, that, from my experience, especially when things start to get shaky, there's really two things that you look at from a director and officer perspective. One is an indemnity agreement, so that there's a tie back into the insurance coverage, and then, you know, double checking the insurance coverage to make sure that it's adequate and that the tail is there. And then we talk here about preserving and deciding where to use cash, you know, starting with employees, taxes, and insurance. And why do you put those things at the top?
Yeah, and so I mean, and depending on the situation, we could use other ones, but generally we want to pay things which may have criminal or personal liability. So, you know, failure to pay various sales taxes or withholding taxes, anything that could really trigger a personal liability, or even criminally, like I said, you want to pay first.
And then one thing I've seen here, that kind of surprises people getting into trouble, is that sometimes you have severance duties, either under a severance pay plan or under an individual executive employment agreement or agreements, and that can often is something that's not carried as a contingent liability on your balance sheet. So as things get close and it looks like people might need to be terminated or the company might stop, you still have a duty to pay out that severance, and it can be a really material. I've seen it in multiple different companies where the company offered, you know, longer term severance opportunities to more people than is common, and then all of a sudden now you've got a couple $1 million exposure that is not only on the books but also is potentially incurs individual liability on behalf of the person who's making a decision not to pay the severance. So it's really a critical thing to be asking about if you're on the board and if you're an officer or presenting information to the other officers of the board to be paying attention to. And then, you know, next we, you know, talk about early engagement with 3 key professionals. Who are these 3, and why are these the 3 that you'd recommend?
Yeah, and I would say that there's other people we could put on the list as well. But I mean, any type of investment banker or somebody that could help you if you're in a cash crunch and you need to sell some assets. They obviously have connections. If you need to gain some sort of cash infusion, investment bankers could help with that. You know, you really want to be engaged with your lender. They generally hold the cards. They generally have a security interest in most or all of your assets. And so from my experience, when a borrower just doesn't want to talk with their lender or ignores them, you don't leave the lender a whole lot of options. You know, if they're not getting communication and information they need, the lender's going to say, okay, then we've got to take action.
So on that, a couple of questions about the lender and their rights. First is, you know, how special is a special assets committee? Is that a good thing? Is that a place you prefer to be as a company with your bank?
Yes, despite the name, if you're a company and you're typically in a special assets group of a lender, you're not that special, or you're not feeling so special.
So I've seen this happen. I say it, you know, with a little bit of humor, but it is a major step, from what I can tell. I'm not a banking lawyer, but to be put into a special assets situation or referred to the special assets group, that should be a major indicator that things are not going well at your company, and that the bank is seeing enough information to say, hey, there's really a problem here. Is that a fair statement, Nate?
Yeah, no, I think that's right. Well, once an asset or once a loan gets transferred from the line group, usually down to special assets, it means there's distress there, maybe a default, but definitely something where the bank is looking at it and has a little bit.
And so as a board member, first of all, I love that you say transferred down. That as a board member, I would want to be asking a lot of questions to the finance team about what does this mean? Why are we in special assets and the like? And then, you know, can the special assets team provide help and support to a company if there's a way through?
You're talking about the special assets team?
Yeah. So let's say I'm a company and I get transferred down to the special assets group. What could I say to them in ways they could really help me as a company?
Yeah, generally it's just being open with your communication. Okay, clearly there's an issue. We understand that. Here's why we think uh, we haven't performed quite as well as we were hoping. Here's what we plan to do about it. Here's a very detailed plan on how we think we can get out of this, and here's the reasons why. And at the end of the day, generally the lender is trying to work with you. Obviously, it can't happen all the time. But if you're the company and you're willing to show that you're open and you're trying, and that you may need to do some things that you don't want to do. You may need to sell some assets. You may need to give some additional security. Whatever it is, those are the things that can make the lender more of your friend.
And I think also for the finance professional, I've seen situations where the CFO or controller has been able to use the special assets group as kind of the the finance manager at the car agency, as a good way to kind of say to the other decision makers, hey, we really don't have a choice here, and here's this person, and they're telling us we really have no choice here. Can you talk a little bit about the self-help options that some of the special assets groups would have if they think there's distress?
Yeah, so typically if there's distress, there's a good chance there's a default under any of the credit documents, and so you look at your remedies. Typically the remedies are you can file a lawsuit against the company, you can file a lawsuit against any guarantor, you can begin foreclosure process, you accelerate the debt and begin foreclosure process of whether that's real property or personal property under the UCC. You may be able to appoint a receiver for the company or over certain assets if you're worried about you just getting access to books and records, and maybe you're not getting and getting a fresh set of eyes in there.
Terrific. So and then I'll kind of end our talk about what to think about when your company's distressed by talking a little bit about the attorney aspect, because we often will come in, frequently we're kind of already working with the company on other issues and the like, but there are a couple things that happen with attorneys that are really helpful. First is that unlike the other professionals, there's an attorney-client privilege for advice and counsel related to the issues that you're facing. And so it's helpful to have an attorney. It's also not very expensive to just assert the attorney-client privilege and be able to monitor and give you advice in that regard. And then also, much like the special assets group or your lender, if you're not in special assets, we often work regularly with other professionals who really can help, whether that's finance experts who can come in and help restructure debt, or sales teams that can help restructure how you're generating your revenue, or investment banking or real estate professionals who can help with the asset divestiture. And so often it's that network that's being tapped into that can be as valuable as the advice that's being received by the attorneys, and also I would say the lenders as well. Is that a fair summary, Nate?
Yeah, and we've used all of those, CROs, the whole line.
Terrific. The attorney-client privilege is important because there may be later people you would not want to have disclosed the email and document correspondence to and the like. So just helpful to add that layer of protection. So that's what to do if your company's distressed. Let's say you're doing fine, and what you're really worried about is your supplier, people who are kind of upstream from you, and they are distressed. And so I want to ask you about the options, but first, how does a company know that their supplier might be in financial stress?
Yeah, it's a good question. I think if you're starting to see that supplies are being late, you're starting to see that maybe there's even unresponsiveness, right? Shows that there's maybe a little bit of a fire going on within the company. I mean, it's really important, especially if your supplier is critical and that can't be, maybe replaced, or you're really depending on a certain supply. I mean, you want to have a good relationship with them. You want to touch base with them often and just kind of vet these things to make sure that there isn't an issue.
You mentioned fire, and there's obviously some forest fires going on now. It's quite terrifying in certain parts of the country. And I think that really illustrates that there may be things happening in the geography or in the region as well that can create kind of an assumption or put you on at least notice that there may be problems starting if there is a company, you start kind of hear rumors in your industry, or you get a call from your banker saying, hey, do you know anything about this particular supplier? And it's not a banker you know, and you look them up and they're in a special assets group, then that's perhaps something that you would give you a clue as to that your suppliers might be distressed. So when you do have that clue, what are some of the recommendations that you give companies about how to manage the risk?
Yeah, I mean, I think a lot of these are common sense. I'm not going to spend a whole lot of time on them, but you obviously don't want to prepay for any supplies. If your suppliers, once they go into bankruptcy or something, it doesn't, maybe out the money, not get the supplies. If a certain supply is very critical, you may purchase an abundance of that. We had a client I helped out about a year ago, big stone company that made huge stone designs, very expensive stone designs. And they were critically dependent on a certain supplier they were the only supplier that had a particular mold that our company used to make these designs. And when the supplier became very distressed, we talked about a lot of different options. We said, well, look, we can even just, our client was willing just to give these guys money, not even as a loan, but just to give them money to keep them afloat for a while, so that they could continue to get these molds. And at the end of the day, and it took a while, we ended up buying the company so that we could get the molds. But there's lots of different options if you have a very critical supplier that's in distress.
Which was essentially your final bullet point there. Look at possibly vertically integrating, right? That this could give you an opportunity to secure the supply chain through vertical integration and at a reasonable price. So one final question on this, and that is that you mentioned the potential loans secured by collateral. What does secured by collateral mean?
Yeah, so just taking a security interest in the particular maybe supply that you want. In this case, that was one of the things that we were considering, is we were maybe giving the company a loan to have it secured by these molds, so that if the company defaulted, we'd at least have security interest in the molds. The problem is there were various lenders that had prior security interest in them, and so that was one of the things that took some time, is we had to negotiate with each of the various lenders, give them a certain amount of money they were comfortable with before they would release their security interest in the molds and allow our client to buy them. But that's always an option, is just taking a security interest in the company and in various assets or whatever.
And is that security registered somewhere so you can know that it's out there before you go about trying to buy it?
Yeah. I mean, most types of security you do through a UCC financing statement. That's typically with the Secretary of State and state where the company is organized. There's certain special types of collateral that you secure otherwise, but generally through a UCC financing statement.
Got it. So you can know whether there's already 10 people ahead of you for the 10 assets that are there.
That's what we did. Yeah, we ran a UCC search, and that was pretty evident.
Yeah. That's the UCC search, by the way, is very inexpensive to do. We have paralegals who do it, and it's a couple $100 usually. Yeah. So now, fortunately, we've got everything lined up. Suppliers are great. we're not having fires. There's no frost that killed the crop. No disease is run through the herd. Everything's good. But how about your customers? First question, I guess, like the other one is, how do you know that your customers might be in distress? What are the warning signs that are there?
Yeah, same type of signs. In particularly if payments are either not coming or they're very much delayed, as opposed to what you're used to. But yeah, I mean, same things. Lack of communication, macro and micro economic elements, things like that.
One of the things I've observed just working with companies is that sometimes the payment delay is not obvious right away. And so you have a customer, for example, who's regularly buying and paying you on a certain schedule, 30 days, 60 days after the invoice. And then it starts to get delayed, but you don't necessarily know it for 60 or 90 days. What kind of tripwires do you recommend people put in place so that they're at least noticing that the customer's got a problem?
Yeah, I mean, common sense ones, right? So having an accountant, if having some sort of trigger, whether it's an electronic or just kind of regular audits, if somebody is not paying further 30 days or 60 days, as you said, it at least sends a notification somehow to someone. I mean, even if they end up paying later, at least somebody's aware that that payment was late. But again, especially critical customers, just really paying attention to where they are and frequent communications.
So the other thing I would mention is to really watch what's happening in the industry and to some extent what's happening with that customer. If you're, for example, a food-related retailer or a food-related supplier, and you're selling into the end retailer, and you know that there are problems in the region, there are problems with that particular type of retailer because of things that are happening within the industry, if other competitors to them go bankrupt, that's often a trigger. If you walk through the store where your products are being sold and it looks like it's dilapidated, that normal maintenance isn't occurring, that they haven't painted in multiple years and things like that, that'll all give you some indications as well that your customers are experiencing distress. And a little bit less true for most food-related businesses and food-related retailers, but everybody, if you're watching the news, you know that retail is under a lot of stress right now. As I mentioned, the companies that were already struggling as of January, February, had kind of lower Christmas time sales and the like. Those companies are filing bankruptcy as we speak. I mean, it's happened over the last 2 months. There have been a lot of them. Companies that are heavily real estate dependent are really struggling if they can't have in-person things. So that's really a big struggle and the like. So, those are some good kind of ways to understand if your customers might be at risk. And then can you talk about what a clawback is and how that works?
Yeah,
the first bullet point.
Yeah, so if a company files bankruptcy, there's a statutory provision in the bankruptcy code, section 1147. And the genesis behind it is if a company is going to file bankruptcy and sort of people knew that was a possibility, we don't want one creditor to get paid and preferentially, where every other creditor did not. And so there's this clawback provision that says if you were paid within 90 days of the bankruptcy case, if you're an insider, it's a year, but typically 90 days within a bankruptcy case, based on what's called an antecedent debt, so it's a debt that was past due, then the debtor or a trustee in a bankruptcy case can actually claw that payment back, which seems a little bit unfair, right? You actually provided goods, you provided services, you got paid, but then they can claw it back. So there's there's ways, and as you'll see on the slide, recommendations on how you defenses to that. So generally, if you know that a company is in distress and you've got a lot of past due bills, typical accounting, you would say you take a payment and you apply it to or to the last invoice. But once a company gets distressed, you sort of want to do the opposite. You want to have that payment go to the most current invoice, because one of the defenses of a preference is what's called contemporaneous value. So I provide you goods and services, and substantially contemporaneous with that, you make a payment to me. That's an automatic defense for a preference. And so, maybe changing payment terms, instead of net 30 or net 60, you're now doing a cash on delivery or something like that. But just something to make a payment correspond to a very recent contemporaneous transaction for providing goods or services.
So this was, to me, Nate, you and I talked about this before, and I was really fascinated by this because it's so simple and yet happens at such a low level in most companies that it's an easy one to miss, but it could really, really help you out. So first of all, for the participants, if you've never been in bankruptcy court, then you've never been that close to God. They have a lot of power, and especially for the parties in the bankruptcy, they have really kind of complete control over what happens. The judge does, and it is so. There's no guarantee. One judge might say that your application of payments was appropriate. Another judge might say, no, we're going to ignore that, but or find a way in the statute that it would be permitted to do the clawback anyway. So there's no guarantee. But normally, if I get, if I'm an ongoing supplier of a customer and they pay me, then I take that payment and I use it to retire the oldest account receivable. And you do that for really smart reasons. And a big one from my perspective is that the statute of limitations starts to run on those invoices and such. And so you want to get them to be extinguished. And so it's the normal thing. If I have a company that, let's say I'm billing $1,000 a month to, they pay me $1,000, I put it to the invoice that's 4 months ago or whatever. If you're concerned that the customer is in distress, it's a lot better for you to take that $1,000 and apply it to this month's invoice rather than the one that's 5 months ago. And the reason for that is that, as Nate described, if you create a record that you're essentially kind of cash on demand or payment for current services, then your chances of retaining that $1,000 are different, better than they would have been if you'd applied it to the last invoice. So that kind of makes sense in a way, because the bankruptcy judge and the bankruptcy system want to enable companies to not file bankruptcy. And if you have a big account receivable, but you still need the product, then the only way to have that occur is to allow the supplier of that product to continue to supply and get paid for it in real time. But the challenge, I think, for companies is that how it gets applied is, not the way you do it 99% of the time. This is just the 1% where it really makes a difference. And the person who actually does the application of it is, a bookkeeper or somebody who's many layers below the CFO or CEO of a company. And so I think it's really important to manage the account receivable anyway for companies, and that in particular, if you feel like your industry or your customer's industry is experiencing distress, to stop and say, okay, what are the tripwires we're going to put into place to understand whether this particular customer is in distress? Second is, how are we going to change our terms of service so that it's more clear? We can create a record that whereas we might have been okay with net 60 or 90, now it's got to be net 15, and we're going to apply the payments to the current invoices and just hold on to the account receivable for a couple months and see how things go. And then finally, don't forget the practical. So you might have this great decision that the head of, chief revenue or sales officer, the CEO and the CFO come up with a great plan, but the devil's in the details. And it could be that if the accountant at who's doing the application of the payments doesn't do it does it in the old way that's right 99%, but not this 1% of the time, you could lose the value and the benefit. Is that, Nate, how did I do? I'm not a bankruptcy or finance lawyer, but is that a fair summary from a practical perspective?
You did okay. Yeah, no, that was,
I was worried there. So anyway, I think it's really it's key because it's counterintuitive if you're not in the bankruptcy, if not thinking about how does a bankrupt retailer, for example, or customer, somebody who's facing possible insolvency, how do they actually keep the lights on? And they have to have goods and services coming in order to actually do it. And I think that's was for me a huge takeaway. We've again talked about it for clients and such in the past as well. So you have a couple of other things. I think for me, some interesting points are that the fourth one here that you might just think about, does it really substantially affect your business? Because it might not. If you have a smaller customer, diversified or the like, then you might have already hedged your risk by not being so dependent like your other client was, as you talked about the molds, the stone molds and the like. And then your final point here is temporary discounts or potential loans to customers secured by collateral. So walk me through, how would that conversation occur? I'm worried about the customer, but I don't want to call, saying, oh, by the way, I hear you're, in financial distress. I mean, how do I even have that conversation?
yeah, I mean, if it's a critical customer, most likely you have a pretty good relationship with them. But yeah, it's, hey, we've been noticing that payments are a little bit late. We've obviously been paying attention to the news and things like that, and understand that your industry may be facing some challenges. How are you doing? How can we help you? Obviously, we value your relationship. You're a huge part of who we are, and a huge customer. We don't want to lose you. What do you need? And maybe that opens the door too much to them asking for, well, hey, we need free, we need huge discounts, or we need. But I guess the takeaway is, I think it's it's better to keep that customer, right, long term, even if it requires some short term discounts, or even loans to help it survive a certain period of time. And again, there's many options on what we can
do. And then I'd say it's don't make assumptions about what's going on, because it could be they had a turnover in a particular department and they just or they signed the check, they forgot to mail it. You never know, those strange things that happen. And then the other kind of takeaway I've experienced is make sure that if you do give a loan or a discount or other thing of value, that you take the kind of standard hygiene things that you need to do, like make sure you get it signed, make sure you get it signed by a person with authority, make sure that if you've obtained a collateral, that you secure that collateral, and also you do the registration and filing of it, which again is super easy to do, but it's filed so that the world's on notice that you're now a secured interest holder in a particular piece of collateral and the like. So sometimes you kind of reach the deal, but those details of having the agreement, having it signed, having the security interest get properly secured is really important. And it's particularly important, obviously, in those kinds of situations. So one of the folks that's listening has an interesting question, and that is that occasionally they get questions from the credit department, this is, I think, probably a banker, about whether they should be willing to share information with other creditors, and particularly primary lenders and the like of a customer. So this is interesting because it kind of tees up really the last and final topic. Her question is, what are your thoughts on creditors communicating with one another about the situation for a potentially distressed customer? So as you're reading the question,
Yeah,
I had a different
yeah,
example of it actually recently. We involving a banker or an accountant firm recommending that a customer talk to either an investment banker or somebody, a real estate agent, somebody who it's clear like, this is a referral with a purpose, as it were. And so this is an interesting question about what are the risks of creditors kind of keeping each other in the loop before bankruptcy is filed? Because once a bankruptcy filed, then kind of the books open pretty significantly, right?
yeah. Well, I mean, once a bankruptcy filed, it's open game. They file statements and schedules with the bankruptcy court, and everybody sees about everything.
So what risk would a creditor have if you're a lender and you know that there are some other lenders, possibly because you see the other security interests and the like? What's the risk, if any, with calling that creditor and saying, hey, I see you're also a secured interest holder in assets for ABC Company, and I'm just curious, what information you could share with me. So on either side of that conversation, what advice would you give to the person receiving the call? Should you say, well, things are great, or things are not great, or what do they say, if anything?
Yeah, I mean, if I have a customer that's in distress a little bit, and I know that there's other creditors out there, I don't think I would talk to them initially. I mean, I would for sure reach out to the customer first and figure out, what the problems are, and if that customer has communicated those issues with the other creditors. If the other creditors are already in the loop, and particularly the lender, then yeah, you may want to reach out to them, particularly if you are trying to work something out with the lender. If you need a lender to release a security interest because you're interested in buying an asset, it makes a lot of sense in those situations. I don't know if I would just go spreading like wildfire that that we have a customer that's in distress, because once you let everybody else know, then the lawsuits can start to be filed, and you really leave your customer without a whole lot of options once that wildfire is kind of started. And so I'm not saying I wouldn't share that, but I would be selective about it. I would want to analyze, what's my purpose? Is it just to tell people? I don't know if I would go about it like that, but if you need to help this customer survive, you really need cooperation from other creditors to lay off the gas a little bit. Then in those situations, it can make sense. And so I don't think there's a answer that's sort of a one size fits all. But those are maybe some considerations to think about.
It's interesting. I'm reflecting on the third bullet point, because we've talked about this, you and I, in the past, that sometimes you have to, kind of spend a little money to keep the asset either literally physically alive, as we experienced recently with in the milk industry, a dairy industry, a creditor who had to give money so feed could be purchased, but of course they paid it directly to the feed lot rather than to the bankrupt estate and the like. And then the same is true with information, that you don't want to create a situation where you're kind of the one pushing them over the edge, because it's your secured assets as well. And so I was thinking, as you were describing that, Nate, that from the person asking the question, what's the downside to asking the question? And the answer is, there actually is a downside. And that is that you're creating a foregone conclusion that the company's not going to make it, because other creditors, either above or below you, are going to tighten up and not give the kind of patience that might be possible to make the company survive. And so you could be the tipping point there. And then from the person conveying the information, there could be confidentiality rights and the like and similarly, you're potentially exacerbating the situation by the disclosure. itself. So in any event, and then, I have seen in point number 4 that the hiring good restructuring experts to come in and potentially putting in a chief restructuring officer who really has power over the CEO, CFO, everybody, can be very effective in changing the dynamic that kind of led to the problem. And so I've definitely seen special asset groups and the like who have effectively required that. So do you have any kind of final comments in the last minute we have here?
Yeah, no, I think my final comment is really a comment I made just barely, which is these are things, we talk about things that we see a lot, but in many contexts, there's not a one size fits all solution. And it really depends on the aspects of each case. Let me just give you one very quick example. We were recently called by a company and they said, hey, we've got $3,000 in the bank and we just realized that it's cost $3,000 to purchase a tail insurance. Should we purchase the tail and essentially walk away? And well, maybe in that case it's good or not. I mean, if that's really your last asset and you're using it to benefit yourself as opposed to your creditors, it could be a breach of fiduciary duties. Whereas, if you get that same question 6 months earlier when things are just starting to get distressed, you may have a different answer. And so, in each case, timing, circumstances, it's all going to change. And so this is more of a presentation on here are some issues to think about. Here's what we encounter a lot. But in no way is this something you should do in every case.
And I think, your mega comment there, which I just hugely echo, is, be honest with yourself from whatever the perspective is, whether it's about your company, about your suppliers, about your creditors. I'd say that the number one error I see happen that really causes problems is magical thinking. There's going to be some miracle that'll happen that'll keep this customer afloat or that will not push the supplier under. So having contingency plans and ready to activate is really important. So with that, a couple of final housekeeping items. So first is that, again, for those who would like CLE credit, look at the reminder email you received yesterday and return that to Michelle Hubble, whose information is here, but also it's on the reminder sheet. We'll then process your continuing legal education, get those certificates back to you. In particular, we really want your feedback on our presentation and both positive and constructive, and also ideas and recommendations on future programs are always very welcome. For those who are listening who are cooperatives, we have issued, as you may have seen, a book on cooperative business law. It's now in its 3rd edition, and for the first time ever, also available on Amazon. So check that out. Kind of fun. Nate, just so grateful for your practical advice to clients over the years and your very practical tips here as well. If anybody has follow-up questions or would like to kind of privately talk through issues with Nate, he's always happy to hop on the phone for a quick consultation, checking conflicts and all that. But give you at least some outlines of things that can be done, and has been really, again, very, very grateful for the practical advice you've given me personally and my clients as well. So we do have other programs in the works, and the next one coming up is at the end of September, September 24. The presentation will be marketing communications, particular social media and influencer guidance in the food, agriculture, and beverages industry, particularly in these times where social media, Zoom, et cetera, is how we communicate with one another. So with that, thank you, everybody. Thank you again, Nate, and in particular, gratitude to 2 people behind the scenes who are Jane Wilgus, who manages our marketing programs for this industry group, and Rima Murphy, who keeps the technology afloat so that we can have these come off without a hitch. So thanks to the 2 of you, and thanks to everybody who's listening. And with that, we'll conclude the presentation.